I usually describe the structure of our firm by quoting something I heard as a child in the panhandle of Texas about a barber shop. I usually say 3 lawyers, no waiting. But the reality is 3 lawyers is a small law firm. And so we have to be careful the cases we take to make sure we can staff them. We make sure we do not overcommit. There are times when we turn down good cases because we've already committed to another client and we're not going to jeopardize that client for a new client. Once the case comes into the firm, there's really no such thing as my case or Robert's case or Coit's case. There are Johnston-Tobey cases, and all 3 lawyers work on virtually every case in the office. We divide up the responsibilities, and there are clearly some cases where Coit may take the lead and I just consult with him and answer his questions as he needs them, or Robert may take the lead and have Coit doing research for him. But in general, I believe we have put together a team that I've wanted all my life in the practice of law. I tend to make the strategic decisions. I tend to be a big picture person. Robert is very detail oriented. Robert tends to do most of the paper discovery and he stays on top of the law, and we have legal assistants that assist in the assembling of the documents. These cases tend to be document intensive. And managing the documents, and today managing computers and electronic data, is a major part of the practice of law. Robert pretty much is in charge of that within the firm. Coit, the newest member of the firm, is increasing in his abilities every day. It's important that he be able to do Robert's job, and it's important that he be able to do my job. And so he will probably tell you that because of that, he thinks he's overworked, because we both make him do our jobs when we can.
At JohnstonTobey, we're known for doing several different areas of law practice. Our motto is, we'll sue anyone who will steal from you with a fountain pen. And you might ask, well, what does that entail? Well, it has 4 main areas that we consider ourselves experts in. The first is legal malpractice. In fact, that's the area that we're best known for both locally and statewide. The second area is accounting malpractice, where a client sues an accountant for making a mistake of some sort. The third area is commercial litigation, which for many years was our bread and butter, involving one business suing another, or an individual suing a business, or a business even suing an individual in certain circumstances. A growing area of our practice is also serving as an expert witness for either the plaintiff or the defense in a lawsuit. That has been an area where people have called on us because we have developed expertise in certain areas, and our expertise is helpful to them in lawsuits. So in a nutshell, if you want to look in terms of what does it mean when we'll sue anyone who will steal from you with a fountain pen, it's those 4 areas.
Well, it's true that the vast majority of cases settle. Cases only settle because you worked really hard and you prepared them and you showed the other side that you're not afraid to try this case, that you have a good case and that you're not afraid to put it into a jury's hands. And if they don't believe that, or if that's not true, they won't settle. Why should they? If there's no risk to them, if they think that it's all just a bluff, then they would never settle. That's why we have a policy of no bluffing. I prepare the case as if I'm going to trial. If the other side wants to be reasonable, I mean, that settlement is a product of both sides being reasonable and cooler heads prevailing. If the other side refuses to be reasonable, well, you only have 2 options. You either fight with them and say, you know what, I'm not going to let you take advantage of me, or you give up. I mean, those are the only 2 options, because if they won't come to a reasonable place, well, then you just have to take it all the way and fight with them. And I approach every case as if that's going to happen, with a hope, and along the way make sure I'm posturing things so that I'm communicating to the other side how the case is going to look at the end, and encouraging them to be reasonable, and hopefully also helping my client get a good understanding of the risks, and so my client wants to be reasonable. And if everybody's reasonable, well then we wouldn't need juries.